I played Space Invaders. Now I can play League of Legends. That's the fast-evolving, innovative world of gaming. Today, my brief is to speak to you about the legal pitfalls that are there in respect of contractual relationships and other developments within the gaming industry. So let me start by going through the value chain with you. And I have a point here. There's a lot of people involved, a lot of businesses, a lot of relationships. And that means a lot of contracts. So it starts with the engine developer, who really creates the raw materials for the game developer to create the imaginative game that ultimately gets sold and distributed. The game developer will distribute and sell the game through distributors. Those distributors could operate through the console distribution system, which is basically hardware sold sometimes through brick and mortar and sometimes through online subscriptions. Or the developer and the game could sell through a distributor that's purely online, so through an Apple or an Android platform where the game is downloaded and deployed by the users either through their own device or through their own PC. That latter development, the use of online streaming in particular, led to the development of online competitions, leading to esport development, which in turn creates a whole broadcast event around gaming industry. Now, as I've said, that's a lot of people, it's a lot of businesses, and it's a lot of contracts that need to be put in place. So, what can go wrong? Lawyers know this best because we usually see things when things have gone wrong. Let me tell you a story. This is a story that happened in Hong Kong in relation to a popular game, now no longer available, called the Ninja Saga. In this particular case, as often happens in this industry, people came together, had great ideas to create a narrative and a game. That was done without any real written contracts in place. Hey presto, when the game was broadcast distributed through Facebook, it became a huge success. When things become a success, that's when people start to scramble back and say, well, what did we agree about this? Now we're in a position where we're actually making money. In this case, there were no contracts really in place. So it was more a question of what people believed they had agreed, and whether that aligned with the actual actions that people had taken at the time. So here, there was one particular person who had provided the capital for the development of the game. In his mind, the capital was being used to fund his business idea and his idea of monetizing the profits from that idea. Now, the actual technical people who were developing the games felt that they were working together as a cohesive group, all as founders, all sharing in the profitability. It all wound up in court. And in the end, the court decided that it was, in fact, the person who was providing the capital for the business that had a clear idea in terms of what the rights of the developers, the individuals who were developing the game, were entitled to. They were, in fact, employees. But if you think about that, that was a situation where there was an employment dispute, there was an IP dispute, basically around software licensing, and there was a corporate dispute about whether there was an entitlement to shares and profits deriving from shares. And it all could have been resolved without it needing to go to court if there had been proper contracts in place from the outset. In this case, employment contracts with the individuals who are providing the development services for the company that was going to own the rights to the game. If that employment contract was in place, there could have been proper and appropriate assignment rights in respect of the IP, making it clear that all of the IP was being transferred to the company. And indeed, to be fair to the individuals who were developing the game, there could have been an incentivization program, an ESOP, an employee share option plan or equivalent, where they could have received more than simply the wages that they would have been entitled to as employees. All could have been resolved by a fairly simple and straightforward contract at the outset. So that's the first pitfall to be avoided. Make sure you have good contracts in place for key elements of your business. Now, what else can go wrong? Well, let me tell you another story. This is a story about what exclusivity means in broadcasting rights or rights to events. Valve Corporation owns Dota, which developed the Dota 2 game. Now, there is a Dota platform. The platform allows gaming personalities or other people to broadcast extracts from Dota games through platforms like Twitch and so forth. Valve sold the rights for an exclusive Dota event, tournament event, to ESL. Exclusive rights. ESL in turn entered into an exclusive arrangement with Facebook to stream that particular event. However, game personalities could still use the Dota platform in order to stream or to comment on particular feeds from the tournament via Twitch on the Dota platform. And this wound up in a dispute. And the dispute really revolved around, what did exclusive mean? Did exclusive mean Dota platforms included, or did it exclude the proprietary platforms related to Dota that were operated by Valve? Clarity in the contracts is critical, and this is the second pitfall that you should avoid. Not only must you have critical contracts in place, but you must be precise and clear about what rights you are granting and how you can go about exploiting those rights in the contract itself. And here's the next potential pitfall for you. Being aware of the laws and regulation that apply to all the features of your game. Now let me give you an example of a specific stream of regulation that's absolutely critical, and that's gambling regulation. Many places in the world will either make gambling illegal, full stop, or will require that a license be obtained in order for gambling businesses to be conducted. So if there are particular features in your game, and in particular about how people compete with each other in that game, then this could, without you necessarily intending it, trip a wire that requires either a license to be obtained or makes things unlawful and illegal in relation to that particular arrangement. So what are some of the core and critical questions you have to ask yourself about gambling regulation? The first thing is to know what gambling means as a matter of law in the particular places where you are distributing the game. Usually it involves an assessment of whether it is a lottery, a game of pure chance, or whether there are elements of skill that are really the dominant feature that's involved. This assessment of whether or not it's a game of chance or a lottery is really quite important. You need to ask yourself, and this is interpreted in different ways in different places, what degree of skill is necessary in order to move the game from something that is something of chance or predominantly chance to something that is skill-based. That may be enough to take things out of the gambling context. That's a subject for you to speak to lawyers about. It's a qualitative judgment according to where you are distributing the game itself. Another issue that you might ask yourself, and this is particularly true in terms of competitive gaming, is what is the consequence of there being an entry fee to the tournament in question or to the competition in question? Does the fact that there is an entry fee mean that it is some form of a wager being placed down that is then contingent upon the ability to be able to win a prize? In some places, that's enough to bring it within the scope of gambling regulation. Again, another key question for you to ask. And then you need to look at some of the aspects or features that happen in-game in respect of your particular game. For instance, in some places, loot boxes would constitute gambling. Now, loot boxes are things that you purchase where you get a random being the critical word here, a random item which may or may not be beneficial in respect of the game that you're playing. That can be considered a lottery or some element of chance that's involved. And that's treated in different ways in different jurisdictions. Again, looking at the features of your game is very important when you're thinking about gambling regulation and how it applies to your game. Let's move on to the future and speak about some of the innovations that may lie ahead. If you look at the gaming industry, it is fast evolving, and likewise, the legal innovations around the innovations happening in the industry have been critical to its success and development. You can look at different inflection points. First, when the distribution model moved to online, then there was a suite of new contracts that were necessary in order to document the rights that were associated with that change in the distribution and sales model. Then online and streaming gave rise to the ability to have competitive tournaments with teams. And that led to innovations around contracts for teams in competition, very much like sports law, as well as event and sponsorship arrangements related to the events and the tournaments themselves. So law has always kept pace with the innovation in the industry and supported its continuing development. One technology that is going to be important in the future of the gaming industry, particularly around the esports aspects, will be blockchain technology. Let me give you some examples of how this might be important. If you look at tournaments, there are a lot of the administration related to tournaments could be resolved by smart contracts that are deployed to organize the tournament itself and to automate payouts to successful participants. You can envisage smart contracts that help in terms of accepting participants into the tournament, allocating them games in which they participate, automatically updating results into league tables, and automatically making payouts to those who achieve milestones that trigger rights to payments in the tournaments themselves. All of this is done in a secure platform, which is visible and is traceable. This could help to avoid not only the administration in respect of running these tournaments, but from the participants' perspective, the risk of non-payment in respect of prizes that they have actually won. Huge development, very, very supportive. Another innovation, again enabled by blockchain technology, will be the use of non-fungible tokens, NFTs, within the gaming sector. If you think of the value that can be created for users of games, the players, where they're able to purchase their own NFT and embed with that the history, the success, the failures of how they have used that particular skin in the games that they are playing. And that then becoming a unique saleable item. Now, if that happens and is combined with the portability of the NFT across different games in a metaverse, then that becomes something that really inverts the IP model relating to the gaming industry, where you will have user or player-led IP that in itself becomes valuable and can be monetized by the users and players themselves. A huge innovation lying ahead. So that brings us to the end of a whistle-stop tour of some of the pitfalls to avoid and some of the promises that lie ahead in the gaming industry. This is such a complex industry that there's so many issues we haven't touched upon. We haven't looked at IP because I know that there's an esteemed panel that's looking at that specifically within this summit. We haven't looked at how you retain and maintain value creation in respect of M&A or investment activity within the sector. These are topics for another day. What we should have brought across to you, though, is that it is so critically important, firstly, to have good contracts in place around fundamental and core aspects of your business, and to be mindful and aware of the impact of law and regulation on aspects of the games that you are developing. Also, keep apace with legal innovations that are coming on stream that will match the innovations within the industry itself. Thank you for your attention, and enjoy the rest of the summit.